In this episode, we will be discussing termination of employment. In the Philippines, termination of employment to be legal must both comply with the substantive due process and procedural due process. Substantive due process means that the reason for termination of the employee must fall under any of the items expressly provided for in the Labor Code. In the Labor Code, there are two possible reasons to terminate a regular employee. One would be the just cause for termination, and the other one would be authorized cause for termination. If the reason for termination of an employee is just cause, it means that the reason for termination is the fault or negligence of the employee. For example, serious misconduct, gross and habitual neglect of duty, willful disobedience of the lawful order of the employer, fraud or breach of trust of the employee, or commission of a crime or offense against the person of the employer, his immediate family members, or his duly authorized representative. And finally, analogous circumstances. If the termination of the employee is because of his fault or negligence, the employer is required to inform the employee which of the items in Article 297 of the Labor Code does that act or will fall under. Other than those listed in Article 297 of the Labor Code, the employee could not be terminated from his employment. I would just like to clarify that the Department of Labor and Employment clarified that if the reason for termination is an analogous cause, which is the final item in the just cause termination, the company must be able to provide a handbook specifically providing for the prohibited act which the employee supposedly committed. It is also possible that an employee may be terminated not because of his fault or negligence, but because of the situation of the employer. Those reasons are listed also in the Labor Code. For example, installation of labor-saving device, redundancy, retrenchment, or closure of establishment. In another section of the Labor Code, it could also be by reason of deceased. These are the reasons that may terminate unemployment here in the Philippines. As mentioned, compliance with procedural due process requirements is an entirely different matter. It is not enough that an employer would have the reason to terminate based on substantive due process. The employer must also comply with procedural due process. The procedural due process for termination differs depending on the kind of termination, whether it's just cause or authorized cause. If it's just cause, the employer is required to provide the employee two notices. The first notice is called notice to explain. That notice to explain will inform the employee of the allegations against him and will provide him 5 calendar days to explain. And the final notice will be the notice of decision, informing the employee whether he is terminated or exonerated from the charges. There is no requirement of separation pay payment in just cause termination. For authorized causes termination, the procedure is different. 2 notices are also required to be given. The first notice is to be given to the Department of Labor and Employment through a form called Establishment Termination Report. This notice will inform the Department of Labor and Employment that a particular employer is intending to terminate employees due to an authorized cause. The second notice would be the notice to the employees. This notice will also inform the employees that a termination will happen due to an authorized cause. In both instances, the termination can only be effective upon service of 30 days. For termination due to authorized causes, the payment of separation pay is required. The amount of separation pay to be paid will be dependent on the reason for termination. So for example, if the reason for termination is labor-saving device or redundancy, the employer is required to pay 1 month per year of service to the employee. However, if the reason for termination is retrenchment to prevent business losses or closure of the establishment not due to business losses, the amount of separation pay would be 1/2 month of salary per year of service. But if the reason for the authorized cause is closure of business due to business losses, then no separation pay is legally required. Note that if the termination is illegal by reason of the fact that there is no just or authorized cause, then the court may require the employer to reinstate the employee to its former position without loss of seniority or other benefits. plus back wages and other damages may be required to be paid. But if the illegal termination is due to the fact that the procedure was not complied with, even though there is just or authorized cause, then the courts will only require the employer to pay nominal damages in the amount of 50,000 pesos in instances of authorized causes or 30,000 pesos in instances of just causes. In summary, in the Philippine jurisdiction, termination of employment may only be valid upon compliance with substantive due process and procedural due process. And that wraps up our special lectures on labor laws. Good luck, future lawyers. I know you can make it. Again, this is Attorney Filemon Ray L. Javier, the author of Labor Law, Principles, Statutes, and Jurisprudence, a syllabus-based bar reviewer. Keep posted for future special video lectures.